Hello, my name is Davidson, Edieya, and I shall be your host on today's discussion on the introductory episode of property law practice. In our today's episode, we shall focus on the scope of property law practice, the objective of property law practice, the various land transactions, the applicable laws, and the ethical responsibility of a lawyer who deals with land transaction. Firstly, the scope. This property law practice shall cover issues relating to real property, which is land. It shall deal with the acquisition, enjoyment, and disposal of real property. Notwithstanding that the focal point is on real property, reference may be had to other category of property like personal property or tangible goods, which is goods that can be moved from place to place, or intellectual property, which represents the work of the mind like trademark, patent, and copyright. Having known the scope of property law practice, what therefore are the objectives of property law practice? Law students or practitioners are expected to have a sound knowledge of property law practice, especially as to the various applicable laws, because there is lack of uniformity of applicable law to property transaction in Nigeria. The law that is applicable in Lagos to tenancy is not the law that is applicable to tenancy in Anambra State. So a lawyer should familiarize himself with the applicable law. So knowledge is the first key objective. Another objective required by the course is skills. A lawyer or a law student must develop the skills of interviewing a client effectively in order to get the requisite information from the client so that he will be able to carry out the client's instruction effectively. We also have the skill of drafting. A lawyer must be able to develop a standard draft of a client's document relating to land, thereby carrying out the client's instruction and in compliance with the applicable law. Otherwise, the lawyer may be subject to discipline for not being competent to carry out the work of a client. Lastly, a lawyer must follow and adhere to the rules of professional conduct. For legal practitioners, a lawyer must have these sound ethical values in him because the profession is based on ethics. A lawyer must familiarize himself with the various rules of professional conduct relating to property transaction. So that is the objective of property law practice. That now leads us to the various land transactions in property law practice. Number one is gift of land. Gift of land is the voluntary transfer of land interest from the donor to the donee without the payment of consideration, without the payment of any money. It may be as a result of love and affection. The difference between gift of land and other transaction of land like sale of land is the lack of the requirement of payment of consideration. The document to effect the land transaction of gift is deed of gift, and the parties to this transaction is the donor and the donee. The party responsible for drafting the deed of gift is the solicitor to the donor. We also have sale of land as another form of land transaction. Sale of land is an agreement between the vendor and the purchaser that the vendor has agreed to sell and the purchaser has agreed to buy a particular land in question. In sale of land, there is transfer of the equitable interest in the land to the purchaser, and this gives opportunity for the purchaser to investigate the title of the seller. The purchaser wants to see whether the seller has the right to sell or he has been in the possession of the property for the statutory period which is required under the applicable laws. The document to effect sale of land is the contract for sale of land, and the parties to sale of land transaction is the vendor and the purchaser. The party responsible for drafting this document is the solicitor to the vendor. Apart from sale of land, we also have an assignment. Assignment is another land transaction which is a higher form of sale of land. Here, there is a transfer of legal interest from the assignor to the assignee. And the document to effect this transaction is the deed of assignment. The parties to the transaction is the assignor and the assignee, and the party responsible for drafting the deed of assignment is the solicitor to the assignee. We also have another land transaction which is tenancy. Tenancy is a grant of term of years or for a specified period with definite commencement date and definite termination date by the landlord to the tenant. But such period is usually below 3 years or exactly 3 years. The document to effect tenancy transaction is tenancy agreement, and the parties to tenancy transaction is the landlord and the tenant. And the party responsible for drafting tenancy agreement is the solicitor to the landlord. We also have another land transaction which is a lease. A lease is a higher form of tenancy in the sense that it is grant of a specified term of years by the lessor to the lessee and is usually above 3 years. The document to effect lease transaction is a deed of lease, and the parties to a lease transaction is the lessor and the lessee, and the party responsible for drafting the lease document, which is the deed of lease, is the lessor solicitor. We also have another land transaction which is mortgage. Mortgage is not a sale, but mortgage is the use of a land property to take a loan as a security. Is giving an assurance to the person he take a loan from that he will definitely pay back. And if he is not able to pay back, he has something that the other party can dispose of. So the summary point of mortgage is that it's nothing more than the transfer of interest in land as a security for the repayment of a loan or the discharge of an obligation, with a condition to redeem the property if the borrower pays back the money within time. The document to effect a mortgage transaction is the deed of mortgage, and the parties to a mortgage transaction is the mortgagor, who is the borrower, and the mortgagee, who is the lender. And the party responsible for drafting deed of mortgage is the solicitor to the mortgagee. That is the solicitor to the lender. We also have other land transactions like a pledge. A pledge is common under the Nigerian customary law. This is the grant of possessory right in land from the pledgor to the pledgee, where the pledgor binds himself or agree to forbear from doing something in respect of an enjoyment or something he has gained from the pledgee. However, one thing must be noted under pledge under our Nigerian customary law is that the right to redeem can never be extinguished. And that is why the phrase, once a pledge, always a pledge. What is given out here is possession, unlike mortgage, where you can give out possession or give out title, usually title. Then under the native law and custom or under Nigerian customary law, a pledge need not be in writing, but it is, however, advisable for it to be in writing in order to prove due execution. However, the mere fact that it is not in writing does not invalidate the pledge transaction. It only places a body on the party asserting a pledge to provide the witnesses in order to prove that the pledge transaction was indeed executed. The parties are known as the pledgor and the pledgee. We also have license as an ancillary activity or ancillary transaction relating to land in Nigeria. A license is a mere privilege by the licensor to the licensee to use the property at the mercy or at the will of the licensor. The license authority is not transferable to any other person. So the licensee cannot transfer either by will, intestacy, or by gift of his right to the license transaction. So if there is any agreement to license transaction, shall be a license agreement, and the party responsible to draft a license agreement shall be the licensor or his solicitor. We also have power of attorney. Power of attorney is a form of agency relationship whereby the principal, in this case the donor, grants the power to the agent, and in this case the donee, to carry out a specific transaction or instruction. And if the authority is made for the agent, which is the donee, to carry out land transaction, the power of attorney must itself be by deed. That was the authority in the Nigerian court case in Abina versus Fahad. A power of attorney made to execute a deed must itself be by deed. So these are the summary land transaction in Nigeria. We mention gift of land, we mention sale of land, we mention tenancy, we mention assignments, we mention leases, we have also mentioned mortgages, pledge, license, and power of attorney. Having known the various land transactions, what are those applicable laws to various land transactions in Nigeria? Firstly, we have the Constitution of the Federal Republic of Nigeria. The Constitution of the Federal Republic of Nigeria is the supreme law in Nigeria. The fundamental human rights provisions of Chapter 4, particularly Section 43 and 44, gives right to every citizen of Nigeria to own immovable property anywhere in Nigeria. And if such right is to be taken away from the citizen, it must be determined by payment of compensation to the individual citizen. So the Constitution of the Federal Republic of Nigeria have a provision interacting with land transaction in Nigeria. Number 2 applicable law is the Land Use Act. The Land Use Act is a primary legislation in land acquisition in Nigeria. Section 1 of the Land Use Act provides that all land in Nigeria shall be vested in the governor, who shall hold it in trust for the benefit of the people. So the governor is more of a trustee who owns land for the benefit of the people. Section 5 of the Land Use Act is also very important to the effect that when the governor grants a statutory right of occupancy, the governor has power to demand the payment of rent for such grants. Section 6 is also very important, the power of the local government to deal with land which is situated in the non-urban area, that's rural area. Section 21 is very important in the sense that for a conveyance or reconveyance of legal interest in land or mortgage to be effective, the consent of the local government must first be sought and obtained if the land is situated in the rural community or a rural area. But Section 22 is to the effect that for a conveyance or reconveyance of property which is situated in urban area to be effective, the consent of the governor must first be sought and obtained. Otherwise, failure to get the local government approval pursuant to section 21 or the consent of the governor pursuant to section 22, such conveyance shall be null and void pursuant to section 26 of the Land Use Act. And this was the court's position in Savannah Bank versus Agilo. So the court in Nigeria has held that failure to obtain the consent of the governor shall make the transaction null and void. Section 46 is also very instructive under the Land Use Act in the sense that the right of occupancy shall not be granted to any person who is not a citizen of the Federal Republic of Nigeria, except with the approval or consent of the National Council of State. So the provisions of the Land Use Act is very important to land acquisition and disposition in Nigeria. Apart from the Land Use Act, we also have the Conveyancing Act of 1881 and 1882. This is the law that is applicable to land transaction or conveyance of legal interest and mortgages in state that is carved out from the old northern region or eastern region. So when a transaction involves sale of land or mortgages and the property is situated in Anambra, Abia, Imo, Enugu State, or Kano, Kaduna, and those states, the resort should be to the Conveyancing Act of 1881 and 1882. We also have the Property and Conveyancing Law of 1959. The Property and Conveyancing Law of 1959 regulates the conveyance of legal interest in land and mortgages in property that is situated in state carved out from the old western region, including Edo and Delta. So if the property is situated in Oyo State, Ogun State, Ondo State, Ekiti, or Edo and Delta, resort should be had to the Property and Conveyancing Law of 1959. As a way of caveat, we must note that the Property and Conveyancing Law of 1959 is not in any way applicable to Lagos State. Lagos have their own Mortgage and Property Law of Lagos 2015, which regulate mortgages in Lagos, or Land Registration Law of Lagos 2015, but passed in 2014, which regulate land transaction and registration in Lagos. Apart from the Property and Conveyancing Law of 1959, we have the Tenancy Law of Lagos 2011, which regulate tenancy in Lagos State. However, the Tenancy Law of Lagos 2011 is not applicable to Victoria Land, is not applicable to Apapa, is not applicable to Ikoyi, is not applicable to Ikeja GRA. The Tenancy Law of Lagos 2011 is not also applicable to some specific property in Lagos, like property which is used for educational institution purpose, and it is being used by his staff or student, or it's a place that is used for care or hospice or mental facility. The Tenancy Law of Lagos 2011 is not applicable to those property. However, the Rent Control and Recovery of Residential Premises Law of Lagos 1977 may be applicable to areas where this Tenancy Law of Lagos 2011 is not applicable when it comes to residential premises, or the Recovery of Premises Law of 1973, which may cover commercial property in areas where the Tenancy Law of Lagos 2011 is not applicable. Apart from the Tenancy Law of Lagos 2011, we also have the Mortgage and Property Law of Lagos 2015, which regulates mortgage transaction in Lagos. We also have the Land Registration Law of Lagos 2015, passed in 2014, which now puts Lagos into one registration district and using a procedure called the Land Information Management System LIMS, which the LIMS is expected to keep certain documents of record like mutation record, register of caution, and all that. How land is being processed, how document is being searched is not covered under the Land Registration Law of Lagos. We also have the Administration of Estate Law. The Administration of Estate Law regulates how a property will be disposed or shared or administered after a person has passed away, especially when the person did not leave a will. Section 49, subsection 5 of the Administration of Estate Law of Lagos, for example, provides that where a person died without leaving a will and the person contracted a statutory marriage when he was alive, such property shall be disposed of in accordance with the hierarchy of persons entitled to administration of estate and letters of administration in accordance with that hierarchy. So, notwithstanding the person's customary law or practice, the Administration of Estate Law will regulate the estate of a deceased person when the person contracted a statutory marriage when he was alive. We also have Administration of Estate Law for other states like Bende State 1959, now applicable to Edo and Delta State. Apart from the Administration of Estate Law, we also have the Companies and Allied Matters Act of 2020. The Companies and Allied Matters Act regulates when a company decides to deal with land or landed property. For example, Section 98 now provides that it is not compulsory for a company to not use or to have its common seal. But if a company chooses to have a common seal, the common seal they shall so have shall be regulated by its articles of association. Authentication of document by a company shall be done by a director or secretary or such officer who is so authorized on behalf of the company to authenticate document on its behalf. So Companies and Allied Matters have one way or the other to interact with land transaction when a company is involved. Apart from the Companies and Allied Matters Act, we also have the Illiterate Protection Act and laws, which regulate illiterate when they execute land transaction. We also have the Land Instrument Registration Law, which regulates land preparation or land instrument or conveyance in the various states. We have the Wills Act of 1837, the Wills Amendment Act of 1852, and the Wills Law of the various states. The Wills Act of 1837 is the primary legislation for wills, especially for states carved out from the old northern region and eastern region of Nigeria. However, because of the rigidity of Wills Act of 1837, which provides that a testator must sign at the foot of the will, there was enacted the Wills Amendment Act of 1852, which states that the testator can sign opposite the foot of the will. However, what matters is that he intended to sign and to make that will effective upon his demise. However, any property or disposition which comes after his signature may have no significant effect in construing the will as a whole. That means effect will not be given to those things that comes after his signature. Apart from the Wills Act and the Wills Law, we also have the Stamp Duties Act, which regulate the fee and the procedure for stamping land document as part of the perfection of a conveyancing document. We also have other laws like the Legal Practitioners Act. The Legal Practitioners Act regulates legal practitioners in Nigeria. Section 15 is very instructive, especially to the effect that it provides for the Legal Practitioners Remuneration Committee, and the Remuneration Committee, in exercise of that power, has now made an order, which is the Legal Practitioners Remuneration for Legal Services, Business and Legal Representation Order of 2023. And this order now have 4 major scales. Scale 1 talking about consultations and legal opinion. Scale 2 talking about charges for incorporation of companies and business name. Scale 3 now talking about charges for litigation. And scale 4 talking about how a lawyer may charge when he carry out land transaction. That's preparation of document for land transaction. This order came into effect on May 16, 2023, and it revoked the Legal Practitioner Remuneration for Legal Documentation and Other Land Matters Order 1991. A lawyer is expected to strictly adhere to the Remuneration Order of 2023. Apart from the Legal Practitioners Act, we also have the rules of professional conduct for legal practitioners. When a legal practitioner carry out his duty relating to land transaction, a lawyer should uphold and observe the rule of law. He shall promote the cause of and foster the cause of justice, shall maintain a high level of professional conduct, and shall not engage in any conduct that is unbecoming of a legal practitioner. A conduct that is unbecoming of a legal practitioner shall be such that is so grievous that a reasonable legal practitioner acting in similar circumstance may not do or carry out such conduct, or such conduct that may be defined by the legal practitioner disciplinary committee to be an act which is unbecoming of a legal practitioner. A legal practitioner is also expected not to aid the unauthorized practice of law. A lawyer must not aid a non-lawyer or aid a lawyer that has been suspended or disbarred from carrying out land transaction, or signing a document which is not prepared by him as if it was prepared by him. A lawyer is also expected not to share his legal fee with a non-lawyer except as provided for in the rule, let's say giving the lawyer's fees to a deceased lawyer's fees to his family or those who was expected to take it after his disease, or is a form of payment to a retired staff who worked in the law office of a lawyer. Aside this, a lawyer is expected not to share his legal fee with a non-lawyer. A lawyer must also avoid the use of intermediary. A lawyer must not allow lay agency to exploit his legal services. A lawyer must have direct interface with his client, because the discussion or interaction as to legal practice or consultation with a lawyer, they are not only privileged, but they are also confidential communication. So there should not be lay agency as intermediary for such purpose. A lawyer is also expected to affix his stamp and seal to document of conveyance which he prepared, and such stamp and seal shall be as approved by the Nigerian Bar Association. So a lawyer is also expected to be dedicated and devoted to the cause of the client. A lawyer is expected not to do anything that would go above the instruction of the client. If he is confused as to the instruction of the client, the lawyer should consult his client. So there are other areas where we shall be looking at when we look at the general ethical issues applicable to property transaction. So those are the summary of the applicable laws to property transaction. Lastly, we shall be looking at the ethical responsibility of a lawyer when carrying out property transaction. A lawyer is expected to follow strictly the rules of professional conduct for legal practitioners 2023. Failure to so do, the lawyer shall be subject to discipline and he may risk either being disbarred from the legal profession, that means his name is struck off from the roles of legal practitioner, or the lawyer may risk suspension for a particular period of time. So for a lawyer not to be subject to these professional misconduct issues, the lawyer is expected to follow the rules for legal practitioners. We have talked about the general responsibility of a legal practitioner when carrying out land transaction, that he should uphold and observe the rule of law. We have also stated that a lawyer should not aid the unauthorized practice of law. We have also stated that a lawyer must affix his stamp and seal when conveying or drafting a conveyance document. Otherwise, it shall be deemed that the document was not properly prepared. Beyond that, we said that a lawyer should be dedicated and devoted to the cause of the client. A lawyer must dedicate his attention, energy, and expertise to the cause of the client. And if there is any room of doubt, the lawyer should consult the client for further instruction, especially if it is fact that does not fall within the lawyer's discretion. A lawyer is also expected to represent clients within the bounds of law. A lawyer must not aid a client to carry out an illegal or unlawful activity. Otherwise, the lawyer will be subject to professional discipline. A lawyer is also expected to display high level of competency when representing a client. A lawyer is also expected to avoid the conflict of interest when carrying out transaction on behalf of a client. If a lawyer, for example, drafts a land document, a lawyer is expected not to represent both the purchaser and the seller in order to avoid conflict of interest. However, he may do this if the clients agree, that both the seller and the purchaser agree, the consideration for the transaction is small, and there is a special relationship between the buyer and the seller. A lawyer is expected not to call at a client's house. What we mean by that is that a lawyer should not visit a client's house or place of business for the purpose of giving advice or receiving instruction from the client, except on the ground of special circumstance. Special circumstance here do not define clearly by the rules of professional conduct, but it will reasonably include where the client is extremely sick, or where the client is extremely old, or where the client is in such custody or confinement that he may not be able to visit the lawyer's office for the purpose of giving instruction to the lawyer. Apart from calling at a client's house, we also have dealing with client's property. When a lawyer receives a client's property or a client's money, a lawyer should promptly pay or give the property to the client. Otherwise, the lawyer will be subject to professional discipline. So he must follow client's instruction, and if it is money, he should either pay it to the client or pay it to the client's designated account. A lawyer must not commingle client funds with that of his personal funds. So a lawyer should follow the rules of professional conduct procedure when dealing with client's property or money. A lawyer is also expected to charge adequate remuneration for his legal services, but such must be in accordance with the legal practitioner's remuneration for business, legal services, and legal representation order of 2023. When a lawyer is charging pursuant to this order, he should know what he's charging for. So he should charge in accordance with scale 4 if he's dealing with maybe property transaction. And the location of the transaction or the lawyer also matter, as under the remuneration order of 2023, the country is now divided into various bands. Band 1 includes Adamawa, Abia State, Enugu, Mo, and all that, including most states in northern Nigeria. Band 2 include Edo, Delta, Nasarawa, Niger, and most states in the west, Ekiti, Ogun, and all that. Then we have Band 3, which is Lagos and FCT Abuja. So when a lawyer is charging his fee in respect of a land transaction, he should consult the legal practitioner's remuneration for business, legal services, and representation of 2023. So that is the summary of our today's discussion. We talked about the scope of the course, that the central focal point of the course is on real property, that is property that is immovable. We talk about objective of the course, that a practitioner or a student should focus on knowledge, skills, and values applicable to property transaction. We talk about the various land transactions in property law practice. We also talk about the ethical issues which is arising when a legal practitioner prepare land documents or deeds or real estate transaction. So those are the summary of this introductory episode. I believe you enjoyed the issues one after the other, the way we follow it up. Join me in episode 2 as we shall be looking at deeds, the meaning of deed, the types of deed, the features of a valid deed. We want to look at where a deed is required, where a deed is not required, parts and content of a deed. My name remains Davidson Edieya. Keep watching my videos, like, subscribe, and share to your friends. For now, stay cool and remain blessed.